The steps in a lawsuit are to start a lawsuit, you've got to file a summons and a complaint with the court. The summons means that whoever is listed as a defendant on the summons is being summoned to court to answer for the complaint you're filing. And in the complaint that you've drafted, you're going to have causes of action, the reasons you're suing that person or the people. And you need to make sure that your complaint is well drafted, that you have supporting allegations for each of your causes of action, and you want to make sure that your complaint isn't subject to attack. Now, once the lawsuit has been filed, you then take the summons and complaint and you serve the defendant or the defendants. You may have seen things about the service of the summons and complaint on TV or on a movie where somebody takes a stack of papers and hands them to somebody and says, "You've been served." That is the process of service. And what you've been served means is that they've been served with the summons and the complaint. The summons telling them that they have to go to court, and the complaint that lays out all the allegations against them. Now, depending on what court they're in, they're going to have somewhere between 21 to 30 days on average to respond to the summons and complaint and file their responsive pleading. Once they file their responsive pleading, it then goes into the discovery stage. That's where you get to ask the other side for information and they get to ask you for information. This is the stage where you get to subpoena documents from other parties, from third parties. You get to set depositions. You get to ask them for certain documents and emails or text messages that they've got in their possession. And you get to ask them specific questions that you've drafted called interrogatories, where we get to ask the other side very pointed and direct questions that help support your case. This is one of the most important phases of a case before trial, and this is where you get those really damaging pieces of information, whether it's from witnesses, whether it's from documents, and you take all of that and you put it together at the last stage, which is at trial. Trial is the stuff that is really sexy. Trial is the stuff that you see usually on TV and in movies because it's so dramatic. That's where you see those dramatic cross-examinations. That's when your lawyer gets to put the information together about what the evidence shows. And ultimately, if your lawyer does a great job, they're going to be able to prove to the judge and jury that you should win and exactly what amount you should win. The standard of proof, the burden of proof in a civil case is more likely than not. They call it preponderance of the evidence. But all it means is it's more likely true than not true. To win a civil case, the burden of proof is just more than 50%. It doesn't have to be a whole lot more. And it's not beyond a reasonable doubt. And ultimately, having the right lawyer help you through this process is critical because lawsuits, especially lawsuits today, are extremely time-consuming and expensive. So you want to make sure you've got a lawyer who knows what they're doing, can do it efficiently, and can present and articulate evidence and information well so that people can understand it. If you've got more questions about this, contact me in my office. We're happy to help you. We've recovered tens of millions of dollars for clients in lawsuits and in civil disputes.